to the webinar today, which will going to be a rather engaging discussion on a range of issues and subjects pertain to the presidential candidates' recent audit that was completed last week and published. Joining me today, we have a group of industry and privacy experts, including Chris Babel from Trustee, Jules Polonowski from the Future of Privacy Forum, myself, and Jeff Wilbur, Vice President of Iconics and also co-author of the report. What we will do on today's webinar is we're going to share the data that's been published, provide a little deep dive into the discoveries on the data security, consumer protection, and privacy practices. And then we will actually connect with our panel and really sharing the observations, discuss learnings, and perhaps also hopefully get some great call to actions from our candidates here, or our participants. So a few disclaimers. I want to make it really clear that as a 501c3, nothing here in the report is considered an endorsement or a condemnation of the candidates, and the data is really provided for information purposes only. Really the goal is to help educate voters really on the security and privacy practices of the candidates. And more importantly, as they visit sites, they should be encouraged to look and evaluate the data sharing policies and make a decision on are those campaigns and initiatives that they want to share their information. Some of the limitations is it's really this analysis was through September 20th, reviewing the site's privacy policies. We do know on one occasion it appears one of the candidates did make a change to the site privacy policy. It wasn't material, and unfortunately they did not change their date of their date stamp of the site. So obviously a challenge there. And then also outside the scope of the webinar or the research is any data sharing agreements that they may be doing with political parties. So again, we're evaluating really what is written on their website and such in those areas. And obviously if such an agreement were to conflict, it would certainly raise certain policy and legal issues if it was in conflicting with their published privacy policy and if there were other practices there. So with those disclaimers out of the way, I do want to walk through the honor roll and the methodology. And this methodology has been developed over the past 7 years. We update it every year as we look at what are security best practices, consumer protection best practices, and privacy enhancing best practices. And this year we've evaluated close to 1,000 websites, and you can see here the breakdown, the top 100 banks, the top 500 e-commerce sites, and so on. And then including this year, then we just completed and added the presidential candidates, which was a total of 23 candidates. The way the methodology works, and again we publish this, it's very transparent, is we evaluate a website in each of these three areas, and they can get a core score of 100 points in each category. We also have bonus points for best practices, which we'll reveal, and additional penalty points if we observe vulnerabilities. And to get named to the honor roll, you have to achieve 80% of the available points, as well as you have to score at least 55 in each category. And we've had a lot of questions on that, and what we're really trying to share is that you could have 100% in 2 of the categories, but if you only had 50 points in one, we feel that that would not qualify you. You're really strong as the weakest link. So that's why we have that caveat there. Jeff, do you have any other insights into our methodology, the background that you want to share with the attendees on the call here?
I think you explained it really well. I guess one point you made that I'll enhance is that we do kind of raise the bar every year in each of these 3 major areas that we assess. So the specifics that underlie each one, it's kind of a moving target, but in a good way. It's reflecting the most recent best practices, and those are published publicly for everyone to see.
Great. And again, we'll be actually, in about another month or 6 weeks, we'll be actually soliciting feedback for the 2016 audit. As Jeff mentioned, where the bar gets raised every year, and touch on some of those things. So the objective of the audit for all these sites as well as the candidates is really to promote best practices as well as provide point organizations to resources available. Second, it is to recognize leadership. It's to shine the positive light on organizations that are doing the best, what we consider holistically looking at security and privacy combined, which we think is really important, and offer also assistance. And I should note that we've reached out to every candidate offering assistance and also inquiring on their, specifically on their privacy policies. We've also reached out to one of the candidates where we observed a vulnerability. And unfortunately, with, I believe, exception of one, we have not received any response back. And Jeff, unless there's something in the last 24 hours, have we heard anything else from any of the candidates?
No, you're right, just one.
Yeah, and that's concerning. And then the other points are, again, to assist consumers. Really, and hopefully what we're trying to do is eventually get where privacy and data security really are points of differentiation and part of the value proposition. But I think one of the most important parts is we need to move from compliance to stewardship. The one candidate who will be unnamed came back to us and said, yeah, we do that, but everyone else does it, so it's okay. And my eyes kind of rolled on that, and first of all, everyone doesn't do that. And the second thing is, just because everyone else does it, does that mean it's right? And that's where we need to move from compliance to stewardship and to what I'd say responsible data practices on those areas there. And by the way, if other panelists, feel free to jump in. But so this slide here, as I mentioned, we've looked at multiple segments. We look at the IR 100, the top 100 retailers in this chart, the top 100 banks, and this is providing a snapshot of those organizations on the same exact methodology, what % qualified for the honor roll. So again, you see social sites, which include dating sites, Twitter, Facebook, and such, as well as document sharing sites such as Box and such. So almost 60% qualified for the honor roll, so that was a highlight this year. Conversely, you see in the far right of the screen, only a quarter or 26% of the presidential candidate states qualified. Not surprisingly, the news sites failed, also only 8%. The reason of the news sites, for perspective, is because of their data sharing, the amount of third-party trackers on their sites, and also their broad privacy policies. IoT, we also found some of those areas, and also many of the IoT devices failed in those areas as well. But so understanding that, so basically a quarter of them, of course everyone wants to know who made the honor and who didn't. Again, these are in alphabetical order here. On the left side, those who are the 6 candidates that, based on the privacy policies and the security practices and their consumer protection practices, that made the honor roll. And on the right side is those who not only did not make the honor roll, but failed this year. And Jeff, can you kind of provide some perspective of, honor roll versus pass versus fail? Because there's been some confusion in the past.
Sure. Well, when you discussed the methodology, we saw that we had the rule where to make the honor roll, you have to have 8% of the 300 baseline points, but not have a failure in any one area. So that would be in school, like saying you have to have a B or better with no F. But if you have an F, we just consider that you have failed. And so in this case, there were no people who didn't make the honor roll who didn't fail. They either made the honor roll or failed. In other sectors, we saw, some sliver that were in between. They didn't have a failure, but they weren't good enough to make the honor roll. But here it was kind of all or nothing.
And that was surprising. So in all the other sectors, we've never shared who failed. But in this case, you either passed and made the honor roll or you failed, we felt at this point we had to be transparent and share that data here. So if you look at sectors, again, the inverse of this is overall failing grades. And again, as I mentioned, the news sites, because of the third-party trackers, again, primarily because they're relying on third-party ads, ad networks that are collecting data and don't provide a meaningful way to opt out of data collection. So that's why they scored so low and failed so high here. But I think more telling is if we look at by category and drilling down a little more on why. So in the case of, on the far left of the screen, consumer protection, the IoT sites failed in the consumer protection area, failed to adopt reasonable practices to prevent email from being spoofed and forged, domain security practices there. Also, they also had the weakest security, if you look in the middle section there. And what's very positive here is you see the zeros in each section to the right, and that's basically that none of the presidential candidates failed because of consumer protection, none of them failed because of site security. Conversely, we see the slide is showing the area of privacy, and so again, significantly 2-to-1 over some of the categories, the candidates failed due to the privacy practices and their privacy policies. We also mentioned consumer protection here, and Jeff, maybe you want to provide a little insights into this area and the strengths here.
Sure. There's a lot of numbers in this chart, but basically this is tracking adoption of email authentication, the two primary forms, SPF and DKIM, DMARC, which helps further protect your domains by allowing recipients of the email to block messages that fail authentication or quarantine them, and then some other domain specific things here. And what we saw, as you mentioned before, was very strong adoption of email authentication, up in the 90s or 100%, which is great best practice, better than any other sector we've ever evaluated. Not surprising because they have pretty new infrastructure, the candidates, so you would think they would fairly easily adopt best practices in those areas. The one big missing opportunity we saw is circled in red there is DMARC. It's very easy to implement. It's just a text record in your DNS, but only one candidate had it. And then you can have a record, so you can see, get feedback on your authentication practices, but you can go further and assert a policy. Do you want the recipient to reject or quarantine failed authentication? And that one candidate who did DMARC didn't even do that. So this is something that should be very straightforward that they could do, and it's really missed opportunity.
Yeah, and the point though why we're very concerned, and from consumer protection perspective, is we're already seeing spoofed and forged emails purporting to come from candidates. And again, without having that DMARC policy, there's no way an ISP can confidently reject that mail. So, and again, we can handle those things in Q&A at the end, or we also have resources. The other areas here is we look, go ahead, Jeff.
Well, yeah, there's one other point I wanted to make on that, I guess, and it doesn't tie into our scoring really, but we did see, because we signed up for all the candidates, newsletters and such, that they use a wide variety of domains to send from, some of which look kind of sketchy, the way they're set up. So if you're a consumer and you're concerned that maybe I'm going to get fake emails from, looking to be from a candidate when they really aren't, some of the practices we saw would actually decrease trust just in the way they were set up. So we have encouraged candidates to be more consistent in use of their email sending domains and tie them more directly to their web domain.
Right. Good point there. This slide here, again, we talks about security. As I mentioned, the candidates had the highest security of any of the candidates, and it was really positive here. And a few other highlights here as we see here. So again, EV, extended validation certificates, relatively low as comparison to banking. Again, banking sites, again, recognizing the spoofing and forging of sites. Always on SSL was very positive. And again, that's encrypting the entire web session, which is really enhances not only data security, but privacy, the ability of someone to monitor or sniff that traffic between the client device and the server. So that we saw very positive. So those are positive opportunities. I would say the biggest miss opportunity on the server side is extended validation certificates. Only, I believe, 3 or so of the candidates had adopted those. So we would expect that to be higher if you look at retailers and get other sites that are dependent on credit card transactions right now. So let's jump into the privacy. And again, here, this is a key area to focus on. This gives you a little bit of a snapshot of the methodology. As Jeff mentioned, we have base points. We also have bonus points. We think certain areas are very, very important to make the policies intuitive and comprehensible to the broadest audience possible that aren't practicing privacy attorneys. So again, layered short notices we think are important. Multilingual policies, use of icons, do not track status. While it is required in California, we did want to track actually the number of sites that clearly stated if they honored a do not track signal. And then the other is tag management or privacy solutions. And we believe all those are bonus points, but the tag management ones really help a site owner to manage all the third-party calls that are occurring on the site. We also have penalty points, sites that had private registrations. We had concerns on that. We did find some of those. The data breach incidents, this is more applicable to commercial sites. We haven't experienced a data breach recently of any of the candidates. And again, FTC or state settlements. And so we're trying to outline here, those are areas that would bring any site down in a score. And if we look here on the site here, we see how did all the candidates do. So the overall privacy score for the candidates at 58 on the left side. And again, that's a normalized number there. So again, the only sites that underperformed them were content sites that are dependent upon third-party advertising. But the thing that drew them down wasn't that, it was the privacy score of the policy. So if you see in the center, an average score out of 10 out of 50. So again, very troubling area there. The tracking score was on par with some of the others, but again, it was really the privacy policy that brought down the candidates, so to speak. And if we look at the areas of bonus points, not a single site had a layered notice. Not a single candidate had an icon, and so we see very few sites that have icons. Though it was very interesting, they had the highest level of privacy policies that were in another language, and that was Spanish. So that was kind of striking. So 21% in Spanish there. And then the do not track disclosure, even though it is required for clear notice, as California disclosure regulations, only 11%. Conversely, again, 52% of e-commerce sites. So that gives you a very quick overview of the data. And I want at this point turn it over and go into discussion with our candidates, our program panelists. Joining me, Chris Babel from Trustee, Jules Polonowski from Future Privacy Forum. So guys, good morning and welcome.
Morning, Craig. I'm glad to know I'm running for an office.
Well, we're all running there. So, as we go into here, is there anything, obviously you've had a chance to look at the report a little bit, and we blew through the data. The biggest concern is the privacy. Is there anything that really jumped out to you, surprised you, concerned you?
Might want to pick one of us. Go ahead, Jules.
No, sorry, Chris. Go ahead. You want to jump in? Go
ahead.
So I think it's interesting to understand what the campaign environment is, is like, having been a candidate and having worked on a number of campaigns over the years. When we get to the presidential level, we're going to be talking about candidates with really built-out sites with significant, web teams and so forth. For most of the candidates right now, their site has been built by a vendor. Their data is held by another vendor. The legal people are the ones who are complying with finance and donations. There's no privacy lawyer. There's no e-commerce lawyer. I'm amazed, frankly, that they're as good as they are. because these are really crazed startups and the kinds of things that the startups of the world sometimes do in this pell-mell. If we don't survive, there'll be nothing to talk about. So let's not worry about that because we got to get to the next debate, next election. They're completely focused on raising money and getting into the next debate. Now that's no excuse, but I do think people should realize that although we look at these people as national brands and prominent first-rate names, when it comes to their electronic infrastructure, this is all rented and borrowed. Now there are some real additional risks, and I think by pointing this out in terms of their sites, you highlight some really critical points. There are some real risks because these are folks who are relying on volunteers who have access to databases. In the old days, you walked the streets and you knocked on doors, and your volunteers had a list of Democratic or Republican voters, or maybe members of the local Sierra Club, so you could, oh, hey, these are people interested in this particular cause. Now your volunteers are walking the streets, and you've given them a big dump of data that includes all sorts of information about their neighbors and all sorts of third-party data that you have purchased and bought. If you started asking some of the hard questions you asked here around how do you manage your vendors, what kind of privacy terms do you have in place, do you train your volunteers, who can access the various databases, you would be quite shocked. And so I think you really show that there really is a problem here, but I think one that we shouldn't be surprised because these really are informal startups that are rushing pell-mell. I certainly hope that what we see going forward is the campaigns as they solidify, as sort of the lower tier candidates drop out, as money starts going to the players who are the leaders, that we see people not only addressing the problems that you proposed, but having the first chief privacy officer. No campaign has ever had a privacy lead. Frankly, no campaign has ever had any lawyer whose goal and total focus is dealing with the privacy and security issues of data. And now that the campaigns are major, the two candidates will be billion-dollar operations with data on every American in the country. And so having a first-class structure is really necessary. The other quick point I'll make, and then hand over to Chris, is it shouldn't be a surprise that candidates share information. They buy it, they swap it. It's a surprise to see anyone sharing it for like actual marketing and so forth. That's a bit of an outlier thing, and I think you highlight that with Carly for Arena. So I don't know if somebody cut-pasted that, but that's really sort of beyond the pale. The fact that they share information, I think voters do need to be aware that when you sign up to get mail from your local candidate, you are very often saying, hey, I've raised my hand, I'm an active Republican, an active Democrat, and you're going to be getting mail from a wide range of parties. So I like the provisions you called for where you ought to be able to get off these lists. Hey, I want to hear from Obama. I don't want to hear from 100 other liberal organizations. I want to hear from this conservative group or that. Today, the basic respect that most companies give, which is you don't want to be on my list, I'll let you off, and I don't generally share your data with a million parties, is not in place, and that's really a problem.
Chris?
Yeah, maybe to add to that, and for those that don't know, I mean, obviously I've been here for a bunch of years as a trustee focusing on privacy issues, but before that I spent 10 years at Verisign on the security issues. So maybe to just highlight a few of those things where that you were talking about, Craig, where companies or where candidates, did really well on a lot of the security things and not as well on the privacy things. I think, to some degree that really aligns with what Jules just described. Is this is really a startup that is going to be around in many cases for a few months. In a few cases, through next November, and while sites and things will continue, this is incredibly temporary infrastructure for most being thrown together as quickly as possible. So when you look at some of the security things where the security concerns have been around for 15 years and things like SSL have been around a long time, And honestly, where in some degrees, putting SSL on a site, that's pretty easy. You go and you buy a cert, and you stick it on a server that comes in the package, and you make certain it's on every site all the time, and every page of every site all the time, rather than not. And that's been a practice that companies, we saw the first SSL cert in '95, and every e-commerce site has had them since the '90s. So it's kind of a common part of everyone's practice. Whereas I think a lot of these kind of newer topics of how all this data is collected, how it's shared, we saw in the last election, a lot of the credit to Obama winning was given to the fact that all of his data sharing technologies for the people on the street on election day worked. And everyone had the info they needed to kind of get people to get out and drive the vote, whereas others didn't have that. It kind of shows you where the privacy side of this is much more cutting edge. How you really collect this, move it from the paper-based methods to digital, distribute it to everyone in the campaign, and importantly, as Jules pointed out, really cross campaigns, and that's where this starts to get tricky. It starts to be less mature. We don't have privacy by design in the way that we have security by design, and when you reach out to 20 vendors to assemble a campaign and want to have it up and running in a matter of months and full bore go, some of these things that are less mature get dropped, and I think that's what we're seeing in a lot of the data that you're pulling here. Pretty good on the security elements, not as good on the privacy sharing elements, and that's what the results show.
So let me, it's interesting. You mentioned like a startup that may not be around long here, and a few things. So the question is, are they commercial entities, and should they fall under regs such as Section 5 of the FTC Act, or state regulations? And especially here, as you see, I outlined in a few slides here of basically saying that we're going to sell your data as we need to. And to your point, many of them not going to be around in a few months. Is that acceptable, or should they, or do they have carve-outs?
To me, maybe I'll talk a little bit first this go. Not being a lawyer, I'm not the best to judge like the FTC, not FTC, states, etc. But to me, there's just this element, and I'll relate it from a consumer perspective, right? When Do Not Call went in, I was excited. I signed up everywhere as a consumer, put my mobile number in there, put my home number in there, all the different numbers, right? And you still then got a lot of calls, and they were all political, either survey-related or campaign-related. And I get kind of to the point of, what the candidates are trying to do here is engender trust with the constituency, get them to come out and vote and support them. And at least for me, at a personal level, not so much, not speaking on behalf of trustee here, that exemption type thing is irritating. It violates the trust that people are trying to build with me at that level, and it kind of goes against the grains of what I would expect and what I've, from a business perspective, focused on kind of building consumer trust online, both at VeriSign and Trustee now for 15 years. And so irrespective of kind of its legality or not, I think when some of these things come out that are so counter to what we hold the standard business accountable to, and consumers have way more interactions with business in a 4-year period, and they do with any candidate during an election, whether it be a 2, or 4, or 6-year cycle, I think you have a consumer expectation that gets built. And I just, in thinking about it from a trust perspective, if I'm on the candidate side, doing things that, violate that day-to-day expectation and trust in what a consumer is seeing from a business comes with potential benefits in the sense that, well, no one's saying I can't do it, it's not illegal, so I will do it, versus the, distrust that you may be causing, and what are the pros and cons of doing that. So without getting into the legalities of it, maybe Jules is better suited to talk about that. I just think utilizing exceptions, cutting exceptions in for yourself just runs counter to the kind of trust framework that you're trying to build if you're running a campaign.
So this is Joseph Jerome. I'm at the Future of Privacy Forum, and I work with Jules. And again, it's been a long time since I've looked at election law or anything, and I think we should be clear. There are a lot of exceptions. A lot of the privacy laws and regulations that we have simply will not apply to these campaigns. And realistically, I don't think it's very likely that you would actually ever see any sort of aggressive enforcement action at a federal or even state level against this sort of thing, because by and large, most of these people are politicians, and they understand the system. You know, that said, that there are really interesting issues here where you know, and this is just I was doing some quick reading about where there are some restrictions, and say, for example, members of Congress, they have ranking privileges. What type of mail they're allowed to send their constituents, and they're allowed to do some degree of electioneering campaigning that way. But certainly candidates, freewheeling candidates, it's no holds barred, and any attempt to try and restrict this, I hate to throw out the First Amendment, but when you talk about political campaigns and it's pretty easy to shift to all this data, much of it publicly available in some respects, is a form of speech, and so I think it's going to be very, very hard to regulate through law or things on the books. That said, I think that this study and OTA should be applauded for showing that there is an issue here. The only way you're ever going to see change in the campaigns is by guilting them in the court of public opinion. And so, I certainly think some of these things look really sort of sketchy to the point where campaigns should be held to account, and the fact that they're not responding is disturbing. And hopefully we can all do a good job of asking questions about these sorts of things. And beyond that, I think it's interesting. Yeah, I think we all do this, and I noticed, Chris, that you were referring to everybody as consumers. We're not really dealing with consumers here. We're dealing with citizens, and I think there's a really important role, and this is, I guess, true of all cases of privacy land, but to do a lot of public education. I just don't think people really understand the sort of data infrastructure that's going on behind these campaigns.
Yeah, and Joe, I think, to Jules' earlier comment is a lot of these have been thrown up. One of the privacy policies talked about games of chance and sweepstakes. So it was very clear, and we didn't highlight that here, but it was very clear that they cut and pasted from some other site, and okay, we have a privacy policy. What's next? But one of the things that's kind of interesting here is this: the sale of data. Some of them say like-minded organizations to any new successor, or in one candidate said to any third party for fundraising purposes. And we think about just 90 days ago, the brouhaha over Radio Shack under their reorganization, where you had the FTC lobbying, I think 40-some state attorney generals petitioned the bankruptcy court, and you saw them there. So, I guess we have double standards, effectively, but very surprising that candidates wouldn't have more sensitivity to this.
Well, I mean, there definitely is a double standard, but to echo what Jules said, when you're in this in a campaign, you're there to win. A couple of years ago, we had had a presentation with Raeed Ghani, who was the chief data scientist of the Obama campaign, and a number of we had FTC commissioners and privacy professionals asking him basic questions. Clearly the guy, he wasn't a lawyer, and he was. But they are asking him point blank, did you ever think about privacy or data protection at all? And he was like, no, I saw data as an asset and a tool, and my job was to figure out ways for us to win. And that was sort of the mindset from top to bottom. And that was the presidential campaign. So there's no way that you're going to have a better situation than any of these other people.
So ultimately, you don't think much has changed since 8 years ago from having that discussion?
Oh, I bet you I imagine it's worse.
Yeah, I tend to agree with that. I don't think that with the increased capabilities of collection and putting databases together and all that, that I can't imagine it's gotten better. It's maybe the same, but it's not better.
There's Ira Rubinstein, who many of you may know. He teaches, I think, at Columbia or New York Law School. He's written some papers, and his concern is, in general, is that candidates have created the most comprehensive big data dossier on consumers. It's everything from their political interests, their personal interests, and suggesting that we do need to rethink about these areas. I have spoken with some state AGs, and off the record they say, well, the primary purpose of these sites aren't freedom of speech. They are fundraising purposes and they are no different than a Kickstarter in that their view is on the legal side, they are really primarily a commercial site.
Right.
But I think, Joe, to your point, most AGs are elected, and you're going to not see anyone really standing up on this. So at what point should consumers be more concerned? And what can consumers do? Or what, you should say, or citizens?
I'm sorry to interrupt. Be very careful what you do. There was this is an article, there was a Q&A the other day about how we give away too much information and passcode. And, basically their final piece of advice was, it's okay to lie a little bit to protect your PII. I give money to a number of candidates and causes, and, I use a lot of sort of not exactly my real or my main email address, stuff like that. I think that's really all you can do at this moment.
Yeah, I think Jules had mentioned it earlier. Some of the things that, back to the consumer-business relationship, right? We've got a set of expectations on things like if you end up on a mailing list, you can somehow get off it, right? Simple things, canned spam, opt-outs, etc. And I think that those, from your work here, we see that that isn't something that has happened kind of across the board when it comes to the campaign-citizen relationship. But I think, Joe, that's a good, helpful way to think about it. While a lot of consumers are, they're all citizens, well, maybe not, but there's intermixing here in the way that you were used to interacting kind of on a day-in and day-out basis with e-commerce sites and how you switch over here. And until some of those simple things are put into systems and the campaigns use them, and really what it comes down to is the service providers for the campaigns adopt them, right? Especially when you're in this early in the cycle. Before things get much more serious over the next year. As a consumer, you're always out to protect yourself. If I went back I want to say it was a year and a half ago, we asked consumers, who's most responsible for their privacy, and they actually answered themselves. Right. I think it was 70+% of the time, and I think there's a general realization of that. And people do need to take care of themselves as best they can. Yes, you need to say who you really are. Yes, you need to say where you really are from an address so that that your donations can be mapped and that sort of thing. But you certainly don't have to give out the email address you give out all the time. There's 100 free email services out there. Pick one, pick a fake one. Don't ever use it again. All that stuff is fine, right? So there are things you can do to protect yourself to some degree. But there are also certainly things that the campaigns can do that would kind of be adopting standard practices that businesses follow in the same interaction with some of these people that I think get more out of your red box to your green box and you're on a roll. And honestly, do they damage the campaign's efforts to be successful? They certainly would help on the building trust side, and I would venture that most businesses would say doing that doesn't really cause any sort of detriment. People don't opt out en masse, but they feel more trusting and confident in that interaction because they've been given the choice.
Well, interesting, Joe, your comment, because actually a few other people have said, I'm going to put misinformation up there if I have to fill out a form, or disinformation and create chaff. And of course, if you create enough, you're effectively polluting. If enough people do it, it pollutes your database in the sense that it makes it less effective. And I guess maybe that becomes an outcome in the absence of user control and disclosure and adherence to FIPS, that maybe that becomes an outcome, and that may become an incentive. I want to tie back, Chris, you mentioned before about the do not call list and the carve-outs that we have, and again, a lot of these things are consumer protection. So, OTA running a small 501c3, we can't get off lists because we aren't afforded that protection of those lists, it appears. But, one of the things that we've tried to do is unsubscribe. And so canned spam, and the question I have is if, maybe there is a carve-out for political candidates and freedom of speech. I will tell you ISPs have shifted their view and said constituent mail, they effectively give preferential treatment to be delivered to the inbox, but candidates who are running that aren't political candidates in the primary purpose, they judge those mail just like any other junk mail or marketing mail. But my specific question is, if they provide a link to unsubscribe, should they have to be accountable for that? In other words, should they, they're giving the consumer the option to unsubscribe, but if they don't, is there any remedy in those type of areas?
Yeah, I mean, again, without being a lawyer in terms of whose jurisdiction that would be, I have no idea. But if you are putting in an unsubscribe and you aren't honoring it, like, you're just basically saying, I don't care about my trusted relationship with that citizen, consumer, whatever, right? I mean, when we talk about core principles of privacy, be transparent, give choice, and then be accountable to that choice. Like, if you've gone through the whole process of saying, I'm clearly emailing you, here's your ability to have a choice, and you don't honor the choices that you've given, talk about a way to bruise a relationship with someone else, whatever the other party is, like, that's the way. So I would say yes from a trust perspective, who's going to come after you as a candidate, that I'm a little less clear on.
Right. Of course, we don't have private right of action under canned spam per se there. Let me throw out another one here, and this is kind of a loaded topic here. So if you had a privacy policy that said we don't share data, and if you did find came across a side agreement which they said they were, so in effect they were violating their own privacy policy. And this is a loaded question. What repercussions would it be at that point? Have they not made a promise in a privacy policy, or again, are they able to say it doesn't apply to us? And I'll go here. The Wall Street Journal contacted us, and actually they came across some information after we published a report, and that several of the candidates have signed data sharing with the RNC, and very possibly this also extends to other parties and candidates that actually signed this. And so, in effect, if this is true, and it would invalidate some of the candidates who we actually gave passing scores. But more troubling, have they not made a promise on the privacy policy, and are they not violating that? And what recourse or what action would that designate? And certainly, in a business, I would suggest that would bring intense scrutiny from the FTC and state regulators.
So this is Joe. I guess this should be obvious to everyone. I think the sharing of what's going on is incredibly confusing. You give, as Jules pointed out, you give money once to one person, and suddenly you're getting email from all sorts of different people, and they're offering you different sorts of opt-outs. And I know it took me years after the last campaign to finally, I think, try to opt out of most of this stuff. But as to your second question, I mean, again, I guess, and maybe this is getting into too much of legal inside baseball. I mean, I guess let's see how Spokio turns out before the Supreme Court, and see if we're going to find that people have standing. Although even then, that's challenging because that's the FCRA. Yeah, it's a very good question, Craig. And I think it's an open legal question.
Yeah. Well, again, I think this is an area that's evolving, and I think ultimately, one of the questions comes back down to is, well, what can consumers do? Unfortunately, we found that not unlike consumer e-commerce sites, we found the longest policy was roughly 3,300 words, and the shortest policy was 250. And obviously, the
did either of them tell you anything good? I mean, was the shorter one or the longer one better? I mean.
Well, again, I'm just making an observation, not something to disparage or support any one candidate. But the longest one was written by someone who worked for Jeb Bush's campaign, and it was the typical legalese that becomes very hard to follow at times. What are they doing and such? So I would suggest that the typical consumer, it wasn't very clear and concise. And then the shorter ones, one of them was actually very positive. I can't remember, but the other one was, again, said nothing. It was actually more of a terms of use on there, or it actually talked about. It looks like they actually cut and pasted some mistake. It said, "Our privacy policy addresses the key issues. See below," and there was nothing below. So, but that's there was a lot of areas, and that was part of our interest. Going back to the end of August, we published a public call to action that we're going to be doing this, and that was part of our goal of saying, well, maybe someone just got inadvertently, someone hit the backspace key and didn't realize it, and we were really trying to give the candidates the opportunity to say, oh, thanks for pointing it out. You're right. It's now been reposted. One of the candidates, we did find, searching their site, we found an orphan privacy policy page. In other words, by orphan, it was not linked to any page. And so again, we obviously did not give them a grade, but again, we reached out to them saying, we found your privacy policy, but it's not connected to any page. You can't search it in the search window. We found it just by crawling the site. And again, that's what's disturbing again. And I guess that's a message we're hearing over and over. It's, the whole area of responsible disclosures, companies that want to help. But whether it's a business or a candidate, you would think that they should have a conduit of someone responding to those mails. And again, the only one that we received an email on was the one back who actually not only did they defend their practices, they threatened us with a suit and a cease and desist order, asserting that our report will disparage people to donate from their site. So that's kind of concerning because our goal here is to help. So we have some time for questions from attendees on the call here. I know we've covered a lot of different topics here. This is important stuff, and I really appreciate not only the Future Privacy Forum and Trustee for being on the call, but also providing guidance leading up to here. And Trustee provided also a lot of the data on the point of trackers on the site. And so, again, using their data as well as from others really provide this comprehensive analysis of what organizations are doing. But if you do have a question, we can open up the mic or you can raise your hand. While we're waiting for that, I do want to, touch on another thing that Chris, that you had started talking about. Is there any reason? I guess we talked about the convoluted privacy policies. Is there any, if you were to speak to a candidate, what would maybe the 3 or 5 things that you might recommend that they could do immediately to improve their disclosure statements?
Yeah, I mean, it's a general theme. There's tons of different places to go. You can come to ours. A bunch of people say, here are the key elements, right? Whether it goes back to FIPS standards, but there are lots of simple ways to just create and utilize and build a simple privacy policy. I worry most about the people that don't have one. I mean, if you don't have one at all, that's really, really problematic. And I think that, like Jules had said, these, it's not the campaign or the campaign staff. It's really a lot of the external parties that are hired to put these through. And they certainly are in an upswing cycle for the next year to get through the elections. But in the off time, you got to work these things out. Privacy is such an important and critical.
Great. I think we got cut off there for a second. Are you back there? I'm sorry, Chris, go ahead.
There we go.
You got cut off there. There was someone that wanted to ask a question, but they're not on the phone right now. And so if you could use the question pane, Jeff Noakes, I know you had a question apparently. So if you want to enter the question pane, we'll certainly take your questions that way. Right now, for some reason, we're not able to connect you on the phone right now. So as we go forward, and we'll take a few more questions as they come in the end here, I do think, Jules made a very open, a very important thing is that, candidates are hiring, these digital marketing agencies. They need to hire a privacy, chief privacy officer, I think, in this point of time. As one of these candidates will likely become our next president, one of the questions is, what does this mean, and what's this mean to, perhaps a future version of the Privacy Bill of Rights that was introduced a few years ago?
Well, this is Joe again. I mean, I don't think it. I mean, let's be realistic. I don't think there's a whole lot that's going on with the Privacy Bill of Rights, and I think it's going to continue to be largely focused on private industry. Politically, you're just never going to see anything passed that is going to restrict the ability of these campaigns to do anything. But maybe this is an unfair question for you, Craig, but I really think what is important here is that you're putting something out that people can see. Is OTA planning on doing, updates over time, or, a follow-up once we're down to 2?
Well, that's been proposed, and it's clearly we've been doing updates every time a new candidate comes and leaves, and just going through the data. We do plan on doing that, and we also have been going back several times just to see if by chance the candidates have made any changes to the privacy policy. So we did capture those. So I think clearly after I think another round. And we do that. I mean, one of the things that we want to be careful again, as a C3 organization, we have to be there's a very fine line of that, and so that's honestly the biggest concern we have once it gets down to 2, if we were to make a statement of that. I think but we do plan to continue looking at this in greater detail. One of the questions was asked, tell me, understand this data sharing. Are you saying that the question is, I understand they may be sharing my email address, but can they also sell my credit card data? And so some of the things that we looked at and actually going to the site to make contributions or to volunteer, it's not just contribution, but to volunteer, some of them ask a lot of profile questions for demographics, your age, your education, your ethnicity, and such. So some of this data gets to be very rich. Some of it's also required for federal election reform. If you are a U.S. citizen abroad, you have to enter your passport number. So the challenge to that question is that it's not defined. They don't define what is sensitive information, and they don't define who they're going to share it with. So conceptually, they could certainly share all that information. As far as their ability to share a credit card, again, I'm not an attorney. I would think they couldn't or wouldn't, but I'm not sure. I mean, Joe, do you have any perspective on that?
Well, yeah, I mean, I don't want to start quoting a bunch of laws at you, but that would, yeah, I don't think anybody would be doing that. Financial information is obviously incredibly sensitive, and I think you're probably less likely to see them sharing that sort of stuff simply because that doesn't help them necessarily win. I mean, all the rest of the stuff you're describing, that's all valuable information, but credit card information, that's clearly just for the purposes of the transaction. I think that stuff is more. You need to worry about security issues when it comes to credit card numbers more than privacy issues.
Right. Yeah, and that's my take of that there. And what we actually did find, many of them that the actual credit card transactions are being done by a third party. It's an iframe or such, or it's a subdomain of another site in there, so they're not actually touching that. And I think in general, credit card transaction, there are those principles and such there. I mean, at that point, that's fraud, and there's no carve out for financial fraud, so that I'm aware of here.
So another thing that we just haven't discussed on this call, and I think is actually interesting also, is, I mean, Jules hit on the vendors, but then also what exactly the role of other companies that these campaigns are working with. The example I think is really interesting is the Obama campaign, I think, was very, very aggressive in its use of Facebook to try and connect supporters. And they were scraping all sorts of information. And Facebook, responding to, I guess, some privacy concerns, actually changed their APIs and restricted their terms of service to sort of limit the ability of campaigns to do that sort of use of their service. And as the campaigns are, increasingly trying to use social media, use all these sorts of other outlets to reach people, if they go a little bit too far out of the line or get a little bit too aggressive, I think there's probably a good role for companies to actually say, you guys can't do that here.
Yeah, it's a good point, I think, in there. Obviously, from the data that we've dug down, they obviously, they you know, there is big data business here, and so there are, again, a lot of appending data with other databases and profiling, and so, you know, in that effect, they're no different than, you know, a very savvy marketer. I think the big fundamental difference is the apparent lack of control. The only candidate that offered appears to be any control is Chris Christie. Though it was, again, buried in, it wasn't an opt-in or opt-out box. It was in the privacy policy, and if you don't want us to share your email and other information, it doesn't really say what information, email us at, you know, xyzchrischristie.com. So, you know, again, that's not necessarily very user intuitive, and I'm not sure, and most of us would consider that as a real opt-out mechanism. So.
Nope.
But nevertheless, I do want to thank everyone. We have a summary of resources on our site here. We will be posting the webinar. In addition, we have some things coming up on the horizon. November 16th, we have a salon dinner with Commissioner Brill and Congresswoman Susan DelBene, where we'll be talking about cross-device tracking and IoT best practices. We have an annual meeting on the 17th for members and invited guests. And then we also have an IoT Trust Summit on the 18th. And again, all this information is on our site and encourage you to get involved. And again, I want to thank Chris and Joe and Jules and Jeff for taking their time and their insights and sharing their information with us. Really provide some great insights and perspectives, and I certainly learned a great deal. So thank you guys very much.